Lords, my lady, I'm very conscious that I do need to address you on control, so I'm just going to very quickly, if I may, just mop up the question from Lord Hodge at the end of just before lunch, and just a few more points on...
Well, we'll try not to interrupt you too often.
and the meaning of as paragraph 174. Lord Hodge, you asked me about the errors of law.
Yes, you gave us a heading, the first tier tribunal's errors of law, and then I think you got distracted by questioning.
So, number one, it erred in law in finding that there was insufficient mutuality of obligation for RMC Lim 1 purposes. 2, and it's really connected to that, the only permissible conclusion on the facts found was that there was sufficient mutuality of obligation for RMC Lim 1 purposes. And 3, it misdirected itself in law and took into account an irrelevant consideration at the RMC Lim 1 stage in its reliance on a right to terminate. And
in reliance on?
A right to terminate. And I hope I've made good those.
Are there particular paragraphs that you draw that from, or not?
159 to 162.
159 to 162, the paragraphs you refer us to. Yes, thank you. Thank you very much.
Can I pick up one point on part-time employment? Sorry, can I just go back on the fourth point? It's really related to the, given its finding that the contract did not start on the Saturday, but started on the Monday. The offer and acceptance. They're all really connected points, but... So the finding that there was insufficient is inconsistent with the finding that the contract for personal service was entered into on the Monday, not the Saturday when they arrived at the stadium. Can I just pick up on one point very briefly in relation to part-time employments that was canvassed yesterday in questioning? And this was in relation to the right of termination because of other work commitments. It has long been the case, and is unfortunately even more common in the current environment, that individuals may have more than one employment with different employers. Very simple but common example. You might work 9 to 5 with one employer and then in the evening have a separate employment cleaning an office building for another employer, or even stacking shelves in a supermarket. The fact that you might not be able to attend work because your day job overruns is part of the factual matrix known to the parties when the parties enter into a contract on a part-time basis. It of itself is not inconsistent with the part-time work being employment. Second point, just in respect of this morning, a point that was made, we were discussing the tax and social security legislation, and just to complete the point on the social security legislation, can I just give you a note? It's section 151 sub 2 of the Social Securities Contributions and Benefit Act, which has a equivalent rule against contracting out for the purposes of statutory sick pay, and that's the equivalent of the provision to that referred to by my Lord Legate in Uber, paragraphs 79 to 82. So that is section 151 sub 2 of the SSCBA, equivalent rule of parties contracting out.
Is that in the bundle?
It's not, I'm afraid, but we can, if you would like, we can arrange for a copy to be provided. Can I then just go quickly to meaning of paragraph 174, which was canvassed yesterday? So 174 of the FTT decision, where it says, standing back as we're required to do, our conclusion is that there was insufficient mutuality of obligation and control in the individual engagements to amount to employment, even though, and then it identifies all of the factors that point to employment. And, Lords, in their printed case at paragraph 13, PGMOL accept that the reference to insufficiency of control in that is the finding for Lim 2 purposes that there was no sufficient framework of control. And of course, all of their submissions in respect of Lim 2 are directed, in respect of control rather, are directed at that Lim 2 test. Well, implicit in that must be a recognition that paragraph 174 is not carrying out a balancing exercise. It is the reference to insufficiency of mutuality of obligation and control. It can't be that in respect of control it's a reference to RMC Lim 2, but in respect of mutuality it's a reference to RMC Lim 3. Moreover, when one looks at the language or the structure of the decision, it follows the RMC 3-stage test. 159 is headed the individual engagements and mutuality. 163, the heading is control. And then do you see at 170, it's the third condition and other approaches. So it follows the RMC 3 stages. In respect of control, the control findings in respect of insufficiency...
Are you moving on to control now?
No,
not yet.
Sorry. In respect of control, 163 to 169 are all directed at the sufficient framework of control test, the Lim 2 test. And do you see 169, the end of that, end of 169 is the reference to sufficient, a sufficient degree of control, which reflects the Lim 2 test, the wording of Miss Justice McKenna, who talks about a sufficient degree of control. And also, 163, do you see they refer there to the 163 in reference to the authorities, refer to the Lim 2 authorities on a sufficient framework of control I'm going to be taking you to. So they are quite right to accept that the reference to insufficient control in 174 must be a reference to Lim 2, but it must follow then that the reference to because it's insufficient applies to both of them. The reference to the earlier reference to insufficient mutuality must be a reference to Lim 1. Make that good also by the fact that when you look at 159 to 162, you see again the wording of sufficient. So having identified some level of mutuality in paragraph 159, in paragraph 160, do you see they identify the question as, in Weight Watchers, Miss Justice Briggs considered whether meeting leaders were employed for tax purposes. In relation to mutuality of obligation, he identified the question as not simply whether there is a contract, but whether the mutual obligations are sufficiently work-related. So there's you've got the reference to sufficiently in 160. It's in relation to Weight Watchers, an RMC Lim 1 case, and we know that the sufficiently work-related is the wage-work bargain in required for mutuality of obligation. Similarly, do you see at 161, the first sentence, this is a case within Miss Justice Briggs' third category, so it is sufficient for there to be mutuality during each discrete contract for work done. However, although not on all fours with the facts of Weight Watchers, it then goes to distinguish why not present here. So this is an analysis of RMC Lim 1. And
it would have been more helpful if they'd had a concluding paragraph at the end of the section on individual engagements and mutuality, like they did in control.
Agreed, but it does. But I've given you the references there to sufficiently, which in my submission make it clear. But also, Prater and Weight Watchers are RMC Lim 1 cases. They're not Lim 3 cases.
Where does this point take you?
It only takes me to the submission that actually what the tribunal is doing at 174 is not finding an insufficiency of mutuality for Lim 1 purposes. It's a finding in relation to a balancing, the Lim 3 balancing exercise.
So although it says standing back there,
Exactly.
it's not actually doing the stage 3.
Yes.
Yeah.
And of course, that's not even my learned friend's primary case, because his primary, as in that is what they're doing, because his primary case is that mutuality of obligation requires the same for overarching as for individual, therefore no error of law on limb 1. The sort of alternative argument being advanced is, well, actually, even if that's wrong, really what they're doing is stage 3. But that's, in my submission, not a permissible reading of paragraph 174, either on its own or read in conjunction with the preceding paragraphs.
What is 174 doing then?
So in my submission, what it is doing is it is there saying, because having identified, in looking at the third condition, it identifies a whole raft of factors that are consistent with employment. And they are summarised there in 174. They summarise what their points are there on that. You'll see, in the individual, so even though the level of integration, the hours worked, the fact the referees could not obviously be described to be in business on their own account, and the fact that PGMOL was their only or primary paymaster in refereeing activities are elements that may be suggestive of an employment relationship. But what they're saying is there's insufficient mutuality of obligation and control, and that insufficient mutuality of obligation and control is a reference back to their findings in respect of stages 1 and 2. As I say, it's common ground that that's what they're doing in respect of stage 2, and in my submission, it must follow from that alone that that's what they're doing in respect of mutuality, but that's also clear from 159 to 162, and the structure of the decision. And can I, so, and also though, can I also say another reason which we do refer to in our printed case as to also why that is right? Can I just give you the reference? It's our printed case at paragraphs 25 and 26. We make the point that the language of sufficiency is the language always used in respect of 2, but also has been used regularly by the Court of Appeal, and we give you 3 cases where that's done. So 3 Court of Appeal authorities in the context of RMC Lim 1, where they've used language of sufficiently, and that's, as I say, paragraphs 25 and 26. So that would explain that use of that language.
And you say it's not a question of being sufficient.
No.
Apart from you have to satisfy a binary test of whether it's present or not.
Those 3 points that I've canvassed with your lordships: contract, personal service, and the middle one is the work wage bargain.
Yep.
Yeah, so you're saying that what Mr. Justice McKenna said on the tin is what's inside.
Exactly.
Yeah.
Precisely. My Lords, can I say this though as well? If limbs 1 and 2 are satisfied, then there will be sufficient mutuality of obligation and control. And if taken into account at the 3rd stage, it's not then a question of sufficiency. If you find that limbs 1 and 2, if you find limbs 1 and 2 satisfied, then mutuality and control on their own cannot result in a finding that it is not employment. It must be in conjunction with other factors. And FDT 174 only relies on insufficient mutuality of obligation and control. And I think my Lord Richards at paragraph 75, it's 832 of Atoll House, when he was discussing the burden of proof, what he did say, though, at the end of 75 was, given that mutuality of obligation and control are necessary elements of employment, there will inevitably have to be factors pointing in the opposite direction, but it is, in my view, no more than that. And they don't identify, and that's really my submission, reflecting the point about sufficiency. because by definition there must be sufficient mutuality of obligation and control in order to get over limbs 1 and 2, because that's what must be consistent with the contract of employment. As my Lord Richard says in paragraph 75, there would inevitably have to be, and I would insert there, other factors pointing in the opposite direction, but is in my view no more than that. And then even in respect of that third stage.
I'm not quite sure that's right in relation to mutuality, in that it may not have helped too much on determining whether it's self-employment or employment,
and that's,
except knocking out some possible contracts.
Oh, but also personal service. Personal service. There's a whole raft of authorities dealing with the vexed question of the right of substitution and whether or not that negates the necessary obligation of personal service.
A contract where the putative employee is free to decide, I don't feel like going into work today, I'm just going to tell them I'm not coming in, and they can't sanction me in any way. That is quite a long way from the sort of paradigm contract of employment. I can see that you say, well, that's not relevant at the first stage, but it would be odd to say it's not relevant as a factor pointing against it being a contract of employment at the third stage.
Sorry, but with respect, I say that's not mutuality of obligation, that's a right of termination.
Yes.
And so, sorry, my submission is addressing here mutuality of obligation. I'm addressing mutuality of obligation. You have my submission about the right to terminate.
But you accept that the right to terminate is relevant at the third stage.
Yes, but the third stage is not looking at the question of mutuality of obligation.
I understand that.
It's looking at the broader point.
Yeah.
But even then, though, lady, you've got my submission that it goes where you've got a right of termination on both sides. They cut both ways. They cancel each other out.
You say they cancel each other.
Yes, but we've got to be slightly careful because, as Lord Richard said in Athol House, at the third stage, it's not a mechanical exercise.
No.
I think he described it as painting a picture from an accumulation of detail. It's an evaluation at that stage.
I don't.
And so it's not quite as mechanistic as saying they're cancelled out. You have to form a view, weighing up different factors.
But equally, it's not so simple as there is a right of termination. And can I then just move on briefly? There was a discussion yesterday about paragraph 76 of Athol House, where Lord Richards makes the point about control at the third stage. Can I just give you a reference, please? Because he doesn't refer to mutuality at the third stage. He's emphasising the control point there. And can I just give you the reference to Lord Justice Arnold, paragraph 169, where he does the same? And that is Authorities 851. It's 168. And it's 168 and 169. The last sentence of 169, which in my submission is consistent with what Lord Richards said in the paragraph 76. Can I then just very briefly say, even if you were against me and you said 174 was the balancing exercise, I would say in any event it was vitiated by the errors I have identified in 159 to 162, mutuality, and the errors in 166 to 169 re the sufficient framework of control that I am now going to go on to demonstrate.
Can I just ask you one thing?
Of course.
I've just been wondering whether the way the first tier tribunal put the points we've been looking at is in any way influenced by the citation from Lord Justice Underhill's judgment in Windle, which they set out at paragraph 152.
So, 2 points on that, my lord. First, you'll note that whilst they do there, in the paragraphs that follow, though, they don't refer to that factor. So in their actual discussion, and so you won't see in 159 through to 173 that factor relied upon. But also, if you look at paragraph 174, it talks about standing back, our conclusion is that there was insufficient mutuality of obligation and control in the individual engagements. And of course, the Windle point relates to the absence of mutuality outside the individual engagements.
And is that right? Because Lord Justice Underhill talks about that it may show a lack of subordination or a degree of independence in the relationship while at work.
But that's not what's said, but that's the point that's taken here, is insufficient mutuality.
Yeah, but he's saying, well, it goes to, I think he's really saying it may go to control.
Right, and if you look at the 163 to 169 paragraphs where they find insufficient control, nowhere there do they rely on Windle or the absence of mutual obligations outside the contract. That's 163 to 169, which I am going to come on to.
All right, thank you.
So with respect, that's not the reasoning.
Yes, sorry.
Can I then just one more point as to how the case was argued below? Can I just give you the references? Upper Tribunal. Upper Tribunal, just paragraph references, if I may.
This is on control now, is it?
No, this is on the scope of the argument below.
Hopefully, yes.
Upper Tribunal, you've got 11 and 14 show you are grounds of appeal.
Paragraphs, these are.
11 and 14. And in 14, you'll note that Upper Tribunal 11 is important because it defines a term. So it defines the mutuality obligation as the Lim 1 requirement. So that's 11 and 14, paragraph 36 of the Upper Tribunal decision, and paragraphs 50 to 1. And of course, what you won't find in the Upper Tribunal decision is any record or any reference to an argument that really this was a Lim 3 balancing exercise. And of course, they would have dealt with it. But you won't see a reference to that there. Remittal, I was asked that question just before lunch. If the question of remittal arises, we would be content with remittal on limbs 2 and 3 only. And
that's logical, given your presentation this morning.
Oh, I'm grateful, my Lord. At least that, but can I say this? Obviously, there is this caveat, not caveat really, but this point. I just raise it now because I will forget if I leave it to after control. Obviously, the first tier judge is now a Court of Appeal judge. So my submission wouldn't be inappropriate to remit it back to her. But there is the second point, which is that if you do find for me, or if you do find in our favour, it will have been on the basis that the analysis of both mutuality of obligation and control, limbs 1 and 2, fundamentally flawed. And that would also be a reason not to remit it back. So what could be done is what my Lord Richards did in another case, Glynn, where the FDT had made fundamental errors. The Lordship may remember that you remitted it back to the FDT to decide on findings of fact made in the original decision. Can I move then to control? I'm promising to do so, and will now do so. I've only got an hour, so I will try and take this quickly.
Well, if you could give us a signpost as to what your essential submission will be on control, and then take us to the authorities if that's what you plan.
Yes. So at the end of the authorities, I was going to take you to what my Lord Richards said in Kickabout. Perhaps I can just do that. It is at 873. And it is paragraph 84D put in context, where Lord Richards I think it's recording there the upper tribunal's finding, because there it was the upper tribunal that that effectively did the finding at stage 2. And they said the fact that TalkSport had little control over how Mr. Hawksby presented the programmes put him in the same category as other highly skilled people, such as a surgeon or a footballer, but did not prevent the existence of a sufficient framework of control for these purposes. And then do you see between H and J on that page, sorry, not that one, then at paragraph 85, this conclusion represented an evaluative judgment on the part of the upper tribunal, and KPL must show that it made some error of principle or had regard to irrelevant factors or disregarded relevant factors, or that it was perverse. And we do say that in this case the FDT did, as I will show you, err in principle. And just to headline that, failed to apply the principles in Zeus. And 2, did take into account irrelevant factors and disregarded relevant factors. And when you take all of those matters into account, its conclusion was perverse. So, just, I my Lord, that just headlines. And just to be clear, that was the conclusion of the upper tribunal and the Court of Appeal, who were both aware that they were dealing with the nature of the decision they were dealing with. But you will note that they directed themselves correctly by reference to the authorities, in particular Zeus, and identifies areas of principle and taking into account of irrelevant considerations and the disregarding of relevant considerations. Can I please then just, I'll try and do it quickly, the authorities. Could I please start with at page 266, please? And it is at page 284C, please.
284.
Yes, please. Again, going back to, all routes lead back to ready-mix concrete, but in my submission there's a reason why this authority has stood the test of time. If one looks at number 2 of the RMC test, he agrees expressly or impliedly that in the performance of that service he will be subject to the other's control in a sufficient degree to make that other master. So just pausing there, the other's control in a sufficient degree. Just you recall I made the point that in paragraph 169 of the FDT's decision they replicate that wording, again making clear that they are applying Lim 2. But also, it's what's the purpose of this exercise? The purpose of the Lim 2 exercise is made clear. It's looking at where the balance of control as to the performance of the task, where the balance of control as between the engager and the individual lies. And it's, in my submission, important not to lose sight of that. Then it's returned at F. You see, as to 2, control includes the power of deciding the thing to be done, the way in which it shall be done, the means to be employed in doing it, the time when and the place where it shall be done. All these aspects of control must be considered in deciding whether the right exists in a sufficient degree, so again the reference to a sufficient degree, to make one party the master and the other his servant. So again, that's the purpose of the exercise. Then this important point, the right need not be unrestricted. And they quote Zeus, "What matters is lawful authority to command," and I'd underline the words, "so far as there is scope for it, and there must always be some room for it, if only in incidental or collateral matters." So it's recognising, and I'll take you to Zeus next, it's recognising that there are some engagements which by their nature the engager cannot control, particularly cannot control in the moment of delivery. And the point that's being made is it's a mistake to focus on that inability to control in the moment, because what matters is lawful authority to command so far as there is scope for it. And there must always be some room for it, if only in incidental or collateral matters. And so it's not a question of balancing the inability to control in the moment against the incidental or collateral matters. It's looking at where the nature of the role is such that you can't control in the moment. You look at, that's not the answer. You look at, there must always be some scope in an engagement for there to be control, incidental or collateral matters, and in respect of those matters, where does balance of control look? And can I just, at this point, flag where I'm going? Can I give you a reference? FTT 168, first sentence. You will see in FTT 168, the FTT say it is relevant to consider the nature of the role. Relevant to consider the nature of the role, and then go on to rely on, to focus on, and rely on the inability to step in during the match. So that's precisely the error, as I'll show you in Zeus now, error of principle. And insofar as it is said, oh, well, what they're doing is they're balancing the inability to step in against the other aspects of control that they find, that's an error of principle. And I'll show you in Zeus why that's right. But can I also then please show you, just back to ready-mix concrete, at the top of 285, it says, Mr. Justice McKenna says, to find where the right resides, one must look first to the express terms of the contract, and if they deal fully with the matter, one may look no further. If the contract does not expressly provide which party should have the right, the question must be answered in the ordinary way by implication. And I think it's common ground, but certainly the authorities are clear that that reference to by implication is not Marks and Spencer's business efficacy. It's a broader process of inference, and that's in paragraph 48A of our summary of the principles that my learned friend agreed with. And I think he gave a slight qualification, which was not in all cases, or it might not be the case in all cases. I'm not sure I understood what the qualification was referring to, but I assume he's meaning where the contract is exclusively documented.
Yes, Mr. Justice McKenna was writing then before certain important House of Lords cases like Prem and Simmons and so on emphasised that the importance of the factual matrix in interpretation. So one cannot read him as being too literal.
I'm grateful. And you'll see in our yes. Yes, and all I was going to say is that in our printed case, you'll see in paragraph 48A, we also refer to Cotswolds at paragraph 8, which also makes the point about what you're entitled to look at. But also I'll take you to paragraph 38 of the Court of Appeal, where Mr. Lord Justice Mummery also deals with the relevance not just of the contractual terms, but of the broader context, which I think is entirely consistent with the point Lord Hodges raised.
Are you suggesting that control is a binary question?
Whether there is a sufficient framework of control, in my submission, it requires evaluation, because it requires looking at the facts and evaluating, does it pass the threshold of in the Court of Appeal in Autoclans, they talk about it, the minimum level of control. In Montgomery, as I'll show you, the Court of Appeal say a sufficient framework of control. And so it's not the same as this Limb 3 exercise of balancing. So I'm not sure, Lord Stephen, does that answer your question? It's not a, if by binary you mean, is it it's not a balancing, it's just sort of balancing all factors. It is a question of But bear in mind, it's a gateway. It's a gateway to stage 3, and it's a knockout blow. Is there a sufficient degree of control to make one master, one master and the other servant? Could I please then just go to Zeus, which is 261. Just before I do that, the point on the express terms, though, is significant, because you do start with the express terms. And in my submission, that's another error of principle that you will see that the tribunal make here, is because actually the contractual documents answer the right of control question here in our case. Because when you look at what the tribunal found was the contractual documentation and the ground that that contractual documentation covered, it makes clear the control that was exercised by Piedmont. Can I, though, go to Zeus, please, 261 of the authorities bundle?
261.
Please. And this is the High Court of Australia. And as I say, it's this judgment that Mr. Justice McKenna cites in Ready Mixed Concrete. So you've got to read the RMC Lim 2 condition with this judgment in mind, because he expressly quotes the bit about...
we saw that at 285.
Thank you.
Yeah. 284.
So this is the Acrobat case. And obviously there are obvious difficulties about exercising control about in respect of an acrobat in the moment. But you'll see that the High Court goes a bit further. Head note, the fact that the work to be performed under a contract involves the exercise by the party obliged to perform it of a particular art or special skill, or, and I'd underline this please, individual judgment or action which the other party cannot in fact control, or in the performance of which he cannot interfere, does not of itself show that the contract is not one of service but an independent contract. The nature of the duties or the circumstances in which they are to be performed may be such as to leave little room for direction or command in detail, but so long as there is lawful authority to command, though the scope for it to be limited, the work is performed under a contract of service and not under an independent contract. So it is saying that in a real-time contract where the real-time nature of the performance, or the fact that the role requires independent judgment without interference, there must still be parts of the engagement that are capable of control, and it is those parts that you look to determine whether or not there is the required control.
But in this case, the only thing that couldn't be controlled was the acrobat's actual acrobatic activity. Everything else could be controlled.
So that's the facts. But can I go through though, because it's that point about independent judgment, and you'll see that the way the High Court have framed this, they don't just have in mind acrobats or performers. Held that a finding that by reason of its nature the work was performed under an independent contract and not under a contract of service could not be sustained.
The paragraph above is relevant too.
When an acrobat was engaged by the proprietors of an itinerant circus for an indefinite period and agreed weekly sum to give with a company.
I mean, yes, that looks just like a contract of employment, doesn't it?
Yes, but that's why the point about control, though.
Yeah.
So that may well be at the third stage, but this is dealing with, and Mr. Justice McKenna treats it as dealing with, and cites it as authority in respect of Lim 2. Sorry, I've just moved the page. Can I then just...
I wonder whether there hasn't been a bit of an evolution in the law, and that once upon a time was looked at really as all about control, governing, provided somebody was providing services personally, is now seen as part of a broader inquiry in which other forms of control, apart from control in the actual performance of the task, are relevant, and other features of dependency and independence.
Certainly by the time of Ready Mixed Concrete.
Well, there it's still, in the way it's phrased, when the third stage is sort of expressed rather negatively.
Yes.
And the emphasis really is on the first 2 points, and then there's a sort of, well, nevertheless, it might not be a contract of service. And
But
Hasn't the law moved further now towards really saying that you look more at the bigger picture?
But only if limbs 1 and limb 2 are satisfied. Because what the authorities are clear, and what Lord Richards was clear in Atoll House is that before you get to that stage, you go through 1 and 2, because they if they're not satisfied, you don't get to that big picture exercise.
I don't think that's in dispute. Lord Leggett's point is that whatever the situation was back in the 1960s, where the nature of employment generally was very different and structured in a different way from what it is now, the stage 3 test might be seen as simply negativing a tentative conclusion reached on stages 1 and 2, but given the nature of the employment market now, stage 3 is assuming a greater importance, and that would, I think, be consistent with Lord Richard's judgment in Atoll House.
And I've not sought in this appeal to go behind.
No.
Obviously, this would have been the if that was our position, then this would be this would have been an opportunity to raise that. But I haven't.
You say it's not an issue before us.
Exactly. But also, yes. But I'm not. Yes, I say it's not an issue before you. But I also in our case, we've adopted what Lord Richard said. Can I then, though, just go to 264, about 15 lines up? There's a reference to Odgers and Union Theatres. Sorry, my lords. It is paragraph 3, but it being paragraph 3 doesn't really help you as to it. So it's about halfway down paragraph 3, just below Odgers and Union Theatres. Having decided cases that go one way or another, the High Court of Australia say, a false criterion is involved in the view that if, because the work to be done involves the exercise of a particular art or special skill or individual judgment or action, and a referee is a classic case of individual judgment or action, the other party could not in fact control or interfere in its performance, that shows that it is not a contract of service, but an independent contract. And then they go on to say, they make the point, it is the view which McKinnon, LJ and Wardle and Kent County Council treat as an error when speaking of a nurse performing duties in a country hospital. He said, apart from authority, I should have thought it clear that the applicant was working under a contract of service with the respondents as her employers within the terms of that definition. It is true that she possessed the skill of a trained and qualified nurse and no doubt impliedly agreed to exercise that skill in return for a weekly wage. But many a person who is clearly a workman within the definition is contract of service and is engaged to exercise some qualification of skill, e.g. a chef, a cabinet maker, a compositor, or even a professional footballer. And then at 4 is the next part. The duties to be performed may depend so much on special skill or knowledge, or they may be so clearly identified, or the necessity of the employee acting on his own responsibility may be so evident. So applies squarely to a referee. That little room for directional control in detail may exist, but that is not the point. So, irrelevant. What matters is lawful authority to command so far as there is scope for it, and there must always be some room for it, if only in incidental or collateral matters. Now, of course, Mr. Justice McKenna doesn't. That's the passage quoted, but it omits the opening words which put them into context.
But do you say that there can be that degree of control, but it is still a contract for services?
Sorry, there can be that degree. So control over the incidental matters.
You could have, your clients could exercise that degree of control over you. Obviously, they engage you for your skill, etc., but they direct in some ways, or they instruct you as to what to, would that be a sufficient level of control for level 2?
Yes. And because, well, I'm struggling to see how if there is the sufficient framework, then it's passed and you go to level 3. I'd want to think about how that works with a barrister.
Well, I'm asking a broader question as to whether, to what extent the decision at level 2 is a pointer to be taken into account at level 3, that this is a contract for service, of service rather than for services.
Sorry, and so now I understand. So the question is not the role it plays at Lim 2, but at Lim 3, and that's the point that both Lord Richards and Lord Justice Arnold address in Our House, where they say that the degree of control, because it may be a borderline case as to which there is a sufficient right of control, and the degree of control, but if it's a borderline case, well then that may be a point, that may be something you take into account at stage 3. But equally, if it's a case where you fly past the threshold, well then equally it's a point that will point to employment. But it all goes into the mix. But
You could have
that's not sorry.
a contract of what would turn out to be a contract of carriage. That is, the putative employer engages somebody to carry goods. He requires them to carry them in a particular type of lorry emblazoned with particular words. He has an element of control over how the carriage is carried out, but it is still a contract of carriage. He gets past Lim 2, he fails on Lim 3.
And I know that Lord Stephen is not creating a hypothetical example. That is ready-mix concrete, and that's exactly the point that Miss Justice McKenna makes in ready-mix concrete, where he says, for our purposes, it's stage 3 that's the important one. So I entirely agree. And then even if Mr. Philipworth could not interfere in the actual technique, the end of 4 technique of the acrobats and in the character of the act, no reason appears why the appellant should not be subject to his directions in all other respects. And then paragraph 5, second sentence, there are countless examples of highly specialised functions in modern life that must, as a matter of practical necessity, and then I would underline these words, and sometimes even as a matter of law, be performed on the responsibility of persons who possess particular knowledge and skill and who are accordingly qualified. But those engaged to perform the functions may nevertheless work under a contract of service. And that applies directly to the referees. And that's the point. And that's why I say that the FTT in paragraph 168, they do take into account the nature, but they don't, what they don't do is they don't heed the direction in the authorities that you don't focus on the fact that the engager can't, as it were, interfere or step in during the performance. You look to see there must be aspects of the engagement that are capable of control, and where in respect of those aspects does the control rest? Is the individual free to carry out those, what would have described as what might even be incidental or collateral matters? Now, as I'll show you, the matters in respect of which Piedmont had a right of control could not be described as incidental or collateral, but even if they were simply incidental or collateral, in applying RMC Lim 2, the correct approach in law is to look at those areas and to see where, as regards those areas, the balance of control lie. And that's, as I say, and I say, it is important, I say, that in setting out Lim 2 and expanding on the meaning of Lim 2, we know that Mr. Justice McKenna had this very authority and indeed the particular paragraphs that I rely upon in mind.
I'm sorry, you said the correct approach is to determine where the balance of control lies.
Well, sorry. I mean whereas between, when I say the balance, I mean whereas between the employer and the engager and the individual, where the right of control lies. So is the in respect of those incidental or collateral matters, is the individual free to carry them out as they wish? Or does the employer control or have the right to control how those parts of the engagement are performed?
Yes, in the case of the acrobat, it would be when in the performance he came in, perhaps even
when he arrived on the day.
Yes, what the nature of the show was going to be.
What he wore.
Yes, and he could be told he has the skill to do it, but he can be told, I want you to show off A, B, and C skills. When
he can leave.
Yes.
And all sorts. There must be all sorts of matters. And as I'll
those things which are outside the specialist skill and knowledge.
Or that require by law non-interference.
Yes.
And as I'll show you here, the FTT just to flag where I'm going. The FTT find as a fact that there were contractual requirements, even in relation to the match day alone, contractual requirements as to when you arrive, what you do when you arrive, how you behave when you arrive, what you wear. And other matters I'll come on to. Those are the matters that are more than incidental or collateral. But why did the FTT disregard them? Because they are focused on, as you'll see, it's paragraph 168, 169, the inability to step in during the match to hoik him or her off, if you disagree with their performance. Bear in mind also that they accept that the PGMOL did have the right to sanction them.
Yes. I think what you're telling us is that you accept that the referee is basically, he's independent while he's refereeing the match. Except in the most extraordinary circumstances, there's no power to interfere with what he's doing. So that's the point, that's stage one. Unlike an actor who is under complete control of the director, not just when he turns up, but in his actual performance. So here, if we're just looking at the referee, what he's doing on the pitch, there's virtually no control over him. So does that not lead to those who are saying there's a contract of employment having to point to other features which indicate that there is control which satisfies Lim 2?
So can I ask
is that schematically correct?
So can I ask that in a stage basis?
Yes.
First, I don't accept the premise that the PGMOL, on the FTT's findings, couldn't exercise control in relation to the performance.
All right.
What they couldn't do is step in during the match and do so.
I see.
That's a separate point.
All right.
Because, and just to flag why I say that.
Well, take it to say. So what you're going to establish, you say, is that they can interfere, they can control. They can't interfere, but they can, through various levers, control the referee's performance. And there may be other features as well you rely on.
Yeah, in two ways. I don't just rely on the after, I rely on the before. Because
okay, well, I think it would.
Because
right.
where you've got a real-time performer, obviously, whilst you can't step in during the performance, you can in the contract direct how it's to be performed, and I'll come on to that.
Well, I'd be much helped by you coming on to how this operates on the facts of this case, personally, but I'm only speaking for myself.
Fair enough. Can I then just do it in this way on the authorities? Can I not take you to them, but just give you the paragraph references, please?
Yes, you can.
Montgomery. It's Authorities Bundle 448, and it's 824D.
Sorry,
824D in the page, the report page,
Yeah.
Sorry.
And it's,
or 448D.
so if I just stick with the authorities bundle pagination, 448,
Yeah.
and it's paragraph 19. And what you'll see there is the Court of Appeal, Miss Justice Buckley in the Court of Appeal. That's where sufficient framework of control comes from. And the reason why, and you'll see what he is addressing there, is the reason why he sort of comes up with this idea of a sufficient framework is because of he's addressing specifically the people who can't be controlled in the moment. So because of the nature of the role, direct control is absent. And so he's saying, well, there still must be a framework of control. Can I then just give you a reference to Troutbeck, the EAT, and the relevant paragraphs are, it's Authorities Bundle 625 to 626. Its summary of relevant legal principles is at paragraphs 37 to 45. And it includes the Zeus citation that we've referred to. That's at paragraph 38. And then also paragraph 45. The question is not by whom day-to-day control was exercised, but with whom and to what extent the ultimate right to control resided. Can I then ask you to go, please, to page 631 of the bundle? I am just going to take you to this paragraph. This is Lord Justice Mummery that I referred to earlier in Troutbeck in the Court of Appeal. The legal error in this case was in treating the absence of actual day-to-day control as the determinative factor, rather than addressing the cumulative effect of the totality of the provisions in the agreement and all the circumstances of the relationship created by it. So, in my submission, that's consistent with what Lord Hodge was putting to me before. You're not looking at just at express terms, you're not looking at just terms implied by contract, you're looking at all the circumstances of the relationship created by it. Can I then, Krista Ackroyd, Upper Tribunal Judgment, can I just give you some references, please? It's Authorities Bundle 750, it's paragraphs 47 to 48. Again, it's the point there about not dealing with Marks and Spencer's. Look at the broader context. Then paragraph 53 to 54, Upper Tribunal then, that's Authorities Bundle 750 and... Sorry. So...
I've got Krista Ackroyd, that I got the paragraphs, and then after that...
So it's paragraphs 47 to 48,
yeah.
And then 52 to 54, please.
Yes.
So those are, they address that the proposition that the absence of an ability to control through sanction, etc. So the absence of mechanics for control in the performance is not relevant. And that's consistent with the authorities I've just shown you. And it's in our list of propositions. But can I just again just flag very briefly, and I'll come back to it. Our case isn't about absence of mechanics. Here, you've got detailed mechanics of control, but the FTT disregard them because they say they only apply after the event and not during the event. And then can I just Uber? Again, I think I will just have to do this by reference to paragraph numbers. It's Uber, paragraphs 75. Lord Legate says the correlative of the subordination and or dependency of employees and workers is control exercised by the employer over their working conditions and remuneration. Paragraph 93, the Supreme Court identified 5 aspects of control correctly found by the ET. Paragraph 94 is the fixing of the remuneration by the engager Same is true here. Paragraph 95. The terms are dictated by the engager, again here, standard terms. Paragraph 96, retention on the part of the engager in respect of discretion. Then paragraph 97 is the monitoring of the performance, second form of control. And the relevance of assessment and monitoring to the control issue. And then 98 is also relevant. 99, a further potent method of control is the use of the rating system, whereby, and that's the passengers are asked to rate the driver after each trip and the failure of a driver and the consequences of that. So it's a potent form of control. And so I'll come on to that in a moment. 101 is also relevant, and also 102 is highly relevant because it talks about regulation and the fact that some of the control exercised by the employer may be due to regulatory reasons. That nonetheless, that doesn't dilute the force of that control. Can I then move to the FTT decision, please? Again, can I do this partly by way of just giving you references, findings of fact that we say are relevant.
Which page number is this?
So in the key documents bundle, I was going to start at paragraph at 29, page 7, please.
So this is your case, yes.
Page 159.
Sorry, 159, it's paragraph 29 of the FTT decision.
FTT decision, I'm so sorry.
So paragraph 29, we've got a finding of fact that the FA is the referee's regulator in the second line.
It's page 208, actually.
It's the difference between the key documents.
Yeah. I'm sorry, you've lost me. What are we looking at?
So this is the FTT decision.
Which paragraphs?
Paragraph 29.
29.
That's the finding of fact that the FA is the regulator.
Yeah. Referee's
regulator. Paragraph 30 is a finding that the FA's disciplinary role sits alongside PGMOL's own disciplinary role. And of course that's important because the FA's disciplinary role is in its capacity as regulator, but PGMOL's disciplinary role is in its capacity as the engager of the referees. And the very existence of a disciplinary role is a very it wouldn't exist if the referee wasn't subject to its control. 37 is the laws of the game. And I'll take you to it in due course when we get to paragraph 168 of the FTT's decision, because they rely heavily on the laws of the game. But of course, what you can see from that is the laws of the game apply to facts connected with play. And actually what the laws of the game are looking at is the position of the referee vis-a-vis a number of participants in the match. So really the wrong place when you're looking at who has control vis-a-vis the engager and the individual. Then you've got paragraph 40 is the finding about PGMOL determining match fees and allowances. Paragraph 42, what's PGMOL's function? PGMOL was created, as you'll see from the first two lines of 42, it was created to oversee the management and administration of refereeing. So its role is to manage the referees. And what are the aims? You get that from line 34, 35. And I say these are all findings of fact of the FTT. The aims behind the formation of PGMOL include a holistic approach adopted for the professional game with a view to ensuring that a high quality...
I'm sorry, where are you reading?
Apologies, it's line 35.
Line 35 of paragraph 42.
Oh, thank you, yes.
Yes. So their purpose is to ensure that there is a high quality and well-trained pool of referees is available. So one has to go back to what are PGMOL doing? They provide the referee services to the competitions. You only have to step back and think, would they really release all control to the referee, given that it's their obligation to provide the referees to the services to the competitions, and it's their purpose to ensure a high quality and well-trained pool of referees is available. You then get 47, please, is the role of the assessors. PGMOL also deals with, it appoints what they call observers, called assessors for the national group, who attend each match to report on the performance of level 1 officials, so the national group. Then each match, they are assessed. The assessors provide verbal feedback to the match officials shortly after the match, then review a DVD of the match, now done online, and complete a detailed post-match report on the official's performance. The assessment procedure results in each referee being awarded a competency score after each game based on a number of criteria, including his application of the laws of the game and his key match decisions. So that's one of the reasons, my Lord Richards, why I hesitate to say yes. And then do you see how that feeds into, please, paragraph 49? Once in the national group, performance is assessed continually using match reports from assessors and clubs, and a merit table is compiled. Relative performance is relevant to selection for appointment to matches, as well as to the performance payments arrangements, and to the potential for joining the select group, i.e. promotion, or being reclassified back to level 2, demotion. So that goes directly to Lord Legate's point about a potent form of control. And it applies to the application of the laws of the game, the performance on the field. Then can I please ask you to go to paragraph, so I've done 49. Can I then please ask you to go to paragraph 54, please? I say I'm just trying to deal here with control relevant findings. 54, PGMOL employs coaches for referees. So these are separate from the assessors. So they employ coaches for the referees. 4 lines down, coaches attending a number of matches and providing one-to-one support in person. Areas for improvement and targets will be discussed and reassessed over time. So again, assessment by the coaches. It talks about at the match, advice, both before may be given. Referees in the development groups would also receive significant support. So that's the cohort of national group referees who have been identified as ready for or close to promotion. So they get even more coaching help. Then most referees will also call their coach after a game to discuss what went well and what might have gone better. Then the support provided might well extend beyond on-pitch performance. And then an end-of-season review would typically be conducted. These are all the hallmarks of employment, not self-employment. Then and it's part of the reason why I do say it's important in this case, at all stages, 1, 2 and 3, to remember that this is not an engagement that takes place ad hoc in a vacuum. You have an overarching contract that has a number of important features that are relevant at all stages of the RMC test. Then 55 I think I can, 59 please. You've got the point that they're appointed on an annual basis. So that's the relevance in part of the end of year review and also the continual assessment. you're only appointed on a season-by-season basis, and the promotion and demotion. And you see that they talk about, if you think about Lord, it's just McKenna's point about servant, master and servant, and everybody says, well, it's rather outdated. But you can see actually the language of serving is actually used in the appointment. And also the reference to career as a national list or national group referee. Then can I ask you to go to 60, please? This is important because these are the contractual documents identified by the FTT. And as you know in the authorities, they tell you the starting point is to look for the right of control as you start with the contractual documents. So, what does the FTT find in relation to the contractual documents? First, you've got the Code of Practice at paragraph 61. There's a requirement to adhere, and you accept the offer. So they'll be expected to adhere to the Code of Practice, and when they sign to accept the engagement, do you see at 15, so it's paragraph 61, line 15, the referee says, I'm pleased to accept the invitation to join the professional game match officials list for 15-16 on the terms outlined above and in the fitness protocol. So that's the terms outlined above are the Code of Practice. What does the Code of Practice include? Look at paragraph 63, please. Under expectations, about 6 lines down, carry out all instructions, procedures and directives relating to match officials. So there you have it. There is control. As between the referee and the engager, the referee, and he signed to accept this. This is the basis on which he signed, this is what he signed up to. The term, to carry out all instructions, procedures and directives relating to match officials issued by PGMOL. You've then got, so that's 63, then you've got 64, please. 64 is, in relation to, again, you look at match day, you'll see in 64, it's the, over the page in 64, there's a reference to the media work that the referee can do immediately after the game. And he's restricted, PGMOL restrict what who he can speak to, what he can say immediately after the game. So this is during the match engagement. PGMOL are controlling him as to him or her, as to he requires their approval, and he or she is only allowed to clarify the fact or points of law. Sorry, so that's 64. 65. Pre-contractual documentation includes the assessments, match assessments, and the feedback system. The contractual documentation tells them about continuous monitoring of performance, with individual appraisals being made when appropriate. And you see there's a requirement to attend meetings arranged by coaches at specific times throughout the season. So that's paragraph 65. So this is all in the contractual documentation. Then you've got at 66 of the PGMOL guidelines. Do you see that in the second line they are described as directives? And you've got the crossover from directives in 66 to the word directives in paragraph 63 in the Code of Practice, where they're expected to follow all instructions, directives. You've got in paragraph 66 that relates to on-field play. And you see the last sentence includes some points of best practice from PGMOL's refereeing experts. And it rather goes to my point about PGMOL employ all of these experts, the assessors. Why is that? Because they are providing the referee services to the competitions and clubs. They have a huge interest in the quality of the performance provided by the referees. It's one of their purposes. Then can I ask you to go to 67, this is important, match day procedures. As you'll recall in 165, the FTT accept that the match day procedures provide rights of control in respect of match day. FTT find in 67, this document sets out certain procedures to follow on match days. The same document deals with the select group and national group. So the select group of the employee are accepted as the full-time employees, and you've got the national group. For national group matches, officials must arrive in accordance with the competition's instructions. They must enter the changing room at least 75 minutes before kick-off, and at the point must switch off their mobile phones, not switching them on again until they leave the ground. Can I ask you to look at the footnote at 7? This is regarded as an important matter given the risk of inappropriate influence, bribery, etc. The reason I refer you to the footnote is because the example that the FTT give of a disciplinary process that the PGMO implemented and suspended was a breach of that point. The referees, during the course of the match, the referee team, during the course of the match, this is the 90 minutes, were on their mobile, had their mobile phones on in breach of the match day procedures. Yes, after the engagement, but they couldn't do it during the engagement. They didn't find out until after the engagement anyway. But after the engagement, their HR people carry out an investigation, they have a disciplinary hearing, and they suspend them for a number of matches. But the FTT disregard that because they say it's not relevant control because it's not exercised during the currency of the match. It's only after the termination of that's only after the end of the agreement. That's a failure to take into account relevant considerations and taking into account irrelevant considerations. Sorry, and then 74 is the promotion and classification criteria. That's important because it again links it to the performance, the on-field performance, taking account of match reports, assessors' reports, the feeding into the merit tables. I'd ask you afterwards to read that, please. Paragraph 75, the Code of Conduct. 75 to 77, again, I'd ask you to read in your own time, but it's, again, applicable to individual engagements. You can imagine when a referee attends a game, they're going to be offered all sorts of hospitality by the host club, and that deals with what they can and they can't accept or do. Then you've got paragraph 80. And again, Code of Conduct, another contractual document. Paragraph 80, match assessors guidelines. 80 and 81 are important. And can I just 81? Can you see they set out all of the important points in 81, all of the important consequences of the assessment. But then you see the last sentence is what's picked up on in the when you get to FTT 165. The clear tone of the interactions with referees is one of advice and assistance in personal development rather than instruction. Simple answer is, so what? You look at what's before that. It's the consequences that matter, not the words that are used. It's the fact that it feeds into whether they get appointed to the next game, what game they get appointed to, whether they're promoted or demoted, and it feeds into their remuneration through the merit point. The words, the tone of the words used can't be relevant and can't be a basis for disregarding that potent form of control. That is paragraph 80 and 81. Paragraph 82. Again, part of what the FTT find is the contractual documentation, is the covering emails, and you see the language there. The emails say the code sets out, this is the code of practice, and the code sets out PGMOL's requirements of you. That's the carrying out the instructions, directives, procedures. You've got then the final sentence on that page, the match day procedures are stated to exist to protect you and the PGMOL, and the importance of adhering to them is stressed. It's the importance of adhering to the match day procedures. And then you see the last sentence over the page that they're required to sign to say that they'll comply with the Code of Conduct. Then can I ask you to go to paragraph 90? Important paragraph regarding disciplinary procedures. PGMOL operates its own disciplinary procedures and did so before the Code of Conduct was introduced. We saw examples of suspensions of a team of officials for breach of match day procedures. And do you recall that that was what I was taking you to? The example in the bundle was the mobile phone example. And you see there it sets out the PGMOL investigation and disciplinary process with the HR manager, etc. And then do you see Mr. Riley explain that where there was a serious allegation of wrongdoing, there'd be a discussion with the FA about who was best placed to investigate it, etc. And then the point is made there that the whilst PGMOL could suspend, it was only the referee who could remove their registration. But that's the same of any professional.
The FA could only remove.
Sorry, the FA, apologies. But it's the same with any professional. The NHS Trust, who dismisses the doctor for gross misconduct, they can't remove his medical registration. It's the regulator who does that, the solicitor, and on and on. And also the critical point is that PGMOL was solely responsible for appointment, and so if they suspended, he could not referee in the professional leagues. And that's what's relevant, is he's engaged by PGMOL to referee in the professional leagues. And PGMOL, vis-a-vis PGMOL could suspend him. That's the finding of fact. Then 169, please.
Paragraph 169.
Please. Sorry, I think that should be 1.5. No, that's a wrong reference. I think it's my. Oh, sorry. Can I go to 149 just briefly? You've got a finding of fact.
149.
149. You've got a finding of fact that PGMOL's regular offers of work is explained by the number of matches available and the limited pool of referees on the list. And then 143, I don't think I took you to. I say 141 is the finding about the contractual document. So 141 is the finding about the contractual documentation that I just referred you to. And then 143 is important.
Yes, we can read that. You only have 8 minutes now, so...
Can I just, though, just read the first bit of 143? The match day procedures document contains a number of obligations, for example, about arrival time at grounds, turning off phones, behaving appropriately, and reporting possible threats to integrity. Code of conduct also places obligations. The final sentence is that they do amount to specific commitments to PGMOL. That's the control in the contractual documentation. Can I then go to 165, please? So just headline point on match day procedures, even if they're right that on the field PGMOL couldn't interfere in the on-field, couldn't control the on-field. You look then at what they could control. That's the law tells you. The match day procedures are the obvious place to look. And you see in 165, they identify them and they say that it gave PGMOL elements of control. Some of those applied to match day activity. And on that, can I just give you 103.5, just a reference, paragraph 103 sub 5. I omitted to take you to it. It says the referee has, it's in something cited, it's from an interview. The referee has total control on the field, subject to the FA referee regulations. Off the field, PGMOL rules apply. Such as in relation to the misuse of social media. But that's reflected in the match day procedures. Off the field, on match day, as it were, the territory is governed by the match day procedures. And really, that should be the beginning and the end of this sufficient framework of control. 166 deals with the assessment and coaching systems. And you'll see they do identify all of the consequences, but at the end, why do they dismiss it? Because of the tone.
Because of the
tone. The tone of the
It's advisory in nature.
Exactly.
Because it's worded as exhortation rather than command.
Yes, exactly. So they disregard the consequences, what they describe as the very important. 3 lines down, the clearly very important. So they themselves acknowledge that these are clearly very important, as they obviously are, but why do they disregard them? Because of the tone. Can I also just give you a reference? It's paragraph 61A of our printed case, which gives you a more detailed summary of the content of the match day procedures. 61A. Can I then go to paragraph 168?
So, the reference was 60?
Sorry, 61A of our printed case.
Oh, 61A of your printed case.
Apologies. It's trying to rattle off at pace. Paragraph 61A just gives you a bit more detail on the match day procedures.
Thank you.
And then we get, so you've got all of those factors that go, that I say of themselves are sufficient, applying the law correctly. Why do they not find it? Because you go to 168. Whilst we would not go so far as to compare referees to clergy, it is relevant to consider the nature of the role. Alarm bells should be ringing at that point. And because they don't say, we take on board the advice in Zeus, that where the nature of the role means you can't interfere, you look at where there is scope for control, the incidental and collateral matters even. No, they don't do that. What they do is they focus entirely on that point about the real time. And they also get it wrong because they say the referee is undoubtedly the person in charge on match day. That's the second and third line. Well, that finding is inconsistent with 165. Match day procedures. It's only, and you'll see that the mistake is clear because they then say he has full authority and his decisions are final. Both of those, the words full authority and his decisions are final, are taken from the laws of the game. And that shows you that shows you also the error. Can I just give you the bundle references for that, please? It's AB 911 is the reference to full authority, and AB 912 is regards for decisions that are final. And they're all talking about facts connected with play. And that's also shown by the next reference to the fourth officials. The fourth officials answer to and work with the referee. So what? Again, it shows they're not taking into account, they're taking into account irrelevant considerations and not taking into account relevant considerations. Interestingly, that point about fourth officials answering to the referee is really, I think, derived from, again, the laws of the game.
What is the irrelevant consideration that's taken into account? I can see your submission in relation to failing to take account of relevant considerations.
So irrelevant consideration is the fact that the engager is not able, because of the nature of the role, is not able to step in and interfere with the performance during the game.
And you say that lack of control is not simply something to be weighed on the balance of the referee against all the other things. It should be excluded, and you just weigh the things excluded from the nature of the role.
Exactly. That is RMC and that is Zeus. And do you recall
Is it irrelevant? Is it not part of the overall picture? But you say, in assessing control, you say this is a specialist skill. That bit isn't controlled, but these other bits, which are within the control, are sufficient.
With respect, that's no, because of that's exactly the point that RMC, with respect, that Mr. Justice McKenna is addressing in RMC, in his description of RMC Lim 2, based on Zeus. And Zeus, of course, makes the point that it may be as a matter of law that they are not able. They're not just doing it practical, but also as a matter of law, you may not be able to step in.
Well, that's a different thing, because there you're looking at things which are not in the control either of the engager or of the...
With respect, no, because it's talking about the, in terms of the referee, insofar as it's the rules, it's the laws of the game, or the yes.
I'm talking generally in
yes,
the use thing. Yes, there are some things which are not in the control of either party.
Yeah, and that I agree.
Obviously, but you go further than that and say even if things appear to be in the control of the individual, if they arise from the specialist nature of the work that he's to do, then you disregard those.
That is ready-mix concrete and also Zeus.
Disregard is at limb 2, taking into account of limb 3.
Yes, and you say the relevant considerations which they failed to take proper account of were the existence of legal authority to control matters outside what happens on the pitch, the various things you've listed.
165, I rely on 165, matchday procedures, the other contractual rights. I rely on the assessments, etc. But
and also you rely on forms of control of what they do on the pitch. The fact they couldn't step onto the pitch and say don't do it doesn't mean they didn't have quite a strong element of control about what the referee would or wouldn't do.
Exactly, and that leads on.
If they got a poor rating on their performance too many weekends on a row, then they might be demoted to the next out of professional football.
But also, and the panel's right, the point about they've taken the right to step in too literally. They've gone and they've applied it, the right to step in during the game. And you see, and of course, it's all derived on the laws of the game. They're quoting full authority decisions upon. It's all based on the laws of the game. But can I answer, Lord Hodge, your other point about it links into?
You
this
must
point.
wind up your submission now.
169 is also important because you can go through every sentence of 169 and also see irrelevant considerations or just simple errors. So they don't take it, a failure to take into account relevant considerations. So in respect of sanctions, they dismiss the sanctions because they're not applied during the engagement. So they recognise that that's a level of, but they say that's outside the arrangements. And then they say, in reality, I say that's so they failed to take into account relevant consideration because they've disregarded it because it's not, you can't do it during. In reality, the only sanction PGMOL could impose for failure to adhere to these conditions was not to offer further match appointments and to suspend or remove the referee from the national group. Well, why isn't that control? So that's a failure. They've disregarded those forms of control. And then the final sentence, 2 sentences. If an issue emerged between a match appointment being made and the date of the match, then the most PGMOL could do in respect of that appointment was to cancel it. They discount that again. They disregard it because they say that's not an exercise of control during an engagement. It's a termination of that particular contract altogether. Well, isn't that the clearest example of a form of control, of the right of control? If an employee commits gross misconduct and the employer summarily dismisses him, he's bringing the contract to the end. Why
Mr. Norbert, you must conclude your submission, so if you want to say something in summary, say it now. You've got 1 minute.
1 minute. The final point is the all of the points made by the FTT in relation to control would apply to all engagements of short duration, because all engagements of short duration, any control necessarily would have to take place, sanctions, etc., disciplinary would have to take place after. But also, is there anything I've not addressed you on that you wanted me to address you on?
No, thank you.
Apologise if I went too fast.
Mr. Peacock.
Lord, I'll propose to address you on 5 matters. Firstly, where we part company with the Commissioners on mutuality. Secondly, the significance of the parties' respective ability to either remove the offer of a match or change one's mind about accepting the match. Thirdly, that point on Turner and Sorden, the old cases referred to in Nethermere. Fourthly, the significance of worker status, the present appeal. And lastly, control. Where we part company on mutuality, important point to note, the case that was advanced on behalf of my clients before the first tier by Mr. Morn was, in the first instance, that there was no contract between PGMOL and the referees because they were paid by the EFL. It wasn't said there was no contract at all, it was said there was no contract with my clients. That contention was rejected. The first tier found that there were both umbrella contracts and individual match contracts. There was no appeal from that conclusion, so the existence of an agreement issue was not in dispute by the time the matter got to the upper tribunal. Our case on mutuality is that the nature and content of mutual obligations should be analysed in categorising the status of any contract where it's said that contract may be a contract of employment. Equally, we say that the test for mutuality should be the same, irrespective of whether one is attempting to categorise that which is labelled an umbrella contract or an individual contract pursuant to some wider umbrella contract. Equally, we say that the tests laid down by His Lordship in the ready-mix concrete case are a useful guide, but they should not be seen either as gateways. Beyond one you cannot pass to the next unless you satisfy the first, nor is it necessarily helpful to think of them as limbs. Be that as it may, the revenue here accept that in a global or overarching contract there must be an obligation to provide and perform some work. Well, in Friend's thesis is then there is no issue as to mutuality when an individual is working under an individual contract, because all that is needed in that agreement is a payment for personal service provided. We say no, that's not right. If the test is to be the same, and it should be, to avoid the problem I identified in opening of having to or categorise contracts before working out what test to apply. So for that reason we say the test should be the same, and then if the test is the same, one does have to regard both the existence and the nature of the obligations that are owed by each side. And my Lord Legate put to me yesterday and put to my learned friend, I think once this morning, that either an obligation exists or it doesn't. And my Lord, of course, is right. That is true. If no obligation exists, then the analysis may well stop there. If an obligation exists, in my submission, one then is entitled, and in this case required, to address the nature of that obligation, and it is not sufficient simply to identify that there is an obligation owed by A to B and B to A. One is required to look at the content of those mutual obligations and to respect, where relevant, that they may evidence a strong, subsisting relationship between the parties designed to endure, to which the law may well ascribe the label contract of employment, or it may be a much looser transactional relationship where the person providing the services may turn out to be, in employment terms, a worker, or may turn out to be self-employed. And why does one have to look at the nature of those obligations? Well, because they are commonly the most important obligations in a contract somewhere in the world of work. One wants to understand in what circumstances will work be offered. One wants to understand in what circumstances will that work be required to be done. And one wants to understand in what circumstances pay will or will not be provided. So one is entitled to ask, as a matter of principle, why would one not look at the nature of those obligations in seeking to categorise a contract as a contract of employment? My primary case in opening and in reply is that that exercise is best done at what Mr. Justice McKenna would have regarded as the first element. But for my part on this appeal, it does not matter whether it is done there or at the third element, provided that it is done. And my own friend suggested faintly that the House of Lords decision in Carmichael establishes that there perhaps is a different test when one is looking at individual contracts compared to umbrella contracts. But that is not what the House of Lords decided. The highest it is put is by Lord Hoffman at page 442, letter D, where his lordship records the conclusion that there was no overarching contract of employment between Mrs. Carmichael and the CEGB. And his lordship says the position may well have been different had the argument been run on the basis of the individual engagements each time Mrs. Carmichael and Mrs. Leese were engaged. But his lordship does not there say that they would have been employees. That he leaves as a matter for another day. So Carmichael is not authority for the proposition that the test is different. My friend also suggested that a reading of the McMeechan decision is also authority for the proposition that there is a different test. And with respect to my learned friend, there is nothing one can get out of the judgment of Lord Justice Waite in that case to that effect. What was in issue in McMeechan was the contention that the court permitted Mr. McMeechan to advance for the first time, namely that he might have been engaged for the 4 days when he worked for Sutcliffe Catering. That contention was accepted, but it was accepted because of the conditions that were imported from the overarching agreement into the agreement he was taken to have with Sutcliffe Catering. But McMeechan is not authority for the proposition that there is some different test for individual contracts. So we say, properly understood, the concept of mutuality, even in the confines of an individual contract, should evidence a continuing obligation to provide work and a continuing obligation to perform that work personally. And whether that is factored in at the first element of ready-mix concrete or the third, for my part, on this appeal, does not matter greatly. From that, it ought to be clear to the court that where we part company most fundamentally with my own friend is the proposition that it is simply enough for payment to be made for work done personally. That is not an adequate discriminating factor between that which might be badged as a contract of employment and my engagement of a decorator to paint my kitchen.
When you say for payment to be made, it has to be made pursuant to an obligation, obviously.
Yes.
I mean, on everybody's case.
Yes, that must be true.
Yeah.
That must be true of every contract somewhere in the world of work. So one cannot leave in the air the notion of mutuality in an individual contract. It would be productive of long-term chaos for this court to say either mutuality in an individual contract is a different test, and or for this court to say that mutuality in an individual contract simply requires work done personally for payment.
I didn't understand the respondents to be saying that. They said that the test under Lim 1 was quite limited, and the factors could be brought back in under Lim 3, and that you didn't argue Lim 3. And that was their case, as I understood it, anyway.
It certainly wasn't how it was put, at least in part this morning, my lord, but if that is the contention, then to reiterate, my primary case is it ought to be at the first element of ready-mix concrete, but if it's at the third, so be it. Provided it is permissible for a tribunal to address the nature and extent of the relevant obligations. So what errors is it said that the first tier made in this regard? Well, my own friend said that the first tier sought to apply the same test of mutuality in individual contracts as in overarching contracts, and that itself was an error. And the first tier also compounded that first error by finding, in effect, insufficient mutuality in relation to the individual contracts. As to the first, it ought to be clear to the court that we say that's not an error of principle. But secondly, it is clear on a fair reading of the first tier's decision that it was alive to the significance of the terms that had been agreed between the parties in the individual contract. It was alive to the terms that had been agreed to between the parties in the overarching contract, and that those terms in the overarching contract may influence the status of the individual contract, and yet that it concluded that whilst there was some mutuality of obligation, having looked at the nature and extent of those obligations between the parties, it was not sufficient to satisfy the required mutuality to give rise to a contract of employment. Now, the way the argument was put, or at least accepted by the Court of Appeal, was to say that somehow the first tier had concluded the ability of PTMOL to take a match away that it had first offered, or the referee to decide that he would not do a match once accepted, somehow negated mutuality. But that is not what the first tier said. So in that respect, at least, the Court of Appeal's judgment below can't stand. They ascribed to the first tier an error it didn't make. Equally, it was said by the Court of Appeal that the ability here of either party not to go through with a match both offered and accepted was somehow immaterial, and that again is to put the matter way too high. It is, in our submission, a material factor, and indeed here a significant one. There is no basis in law to contend that it is immaterial, so that part of paragraph 122 in the Court of Appeal is, with respect, we say, wrong. My learned friend then had a pleading type point that somehow we had conceded below, or we had accepted that the first tier was looking at ready-mix concrete's third element, and that somehow this was not part of this appeal to this court. And I'm afraid that's not right. We accepted that the first tier had looked at the third ready-mix concrete element, and it had addressed both the nature of the mutuality that it had found, i.e. some, and concluded that it was not sufficient to constitute mutuality in the required sense. We were and are happy with that exercise and with the first tier's conclusion, and we did not say either in the upper tribunal or in the Court of Appeal that somehow the first tier had misunderstood the requirements of ready-mix concrete. And of course, my own friend...
Just didn't quite understand. You say it doesn't really matter whether you bring in mutuality under Limb 1 or extended mutuality, under Limb 1 or Limb 3.
Yes.
Did you make that case before the Court of Appeal? You said this should have come in under Limb 3.
I said either 1, or if not 1, then 3.
Yeah, okay.
The case your lordships and my lady has heard, I'm afraid, is the same case that the Court of Appeal heard and found wanting. It's none the worse for a repetition. I hope.
Well, every appellant has to make that argument.
Yes. Well, that has to be my starting point and my ending point. My friend said this afternoon, well, he was asked to identify what errors were made by the first tier. He said 3. They were threefold. First, the first tier erred in finding insufficient mutuality in RMC Limb 1, as he put it. And I say that's not what the first tier did on a fair reading of the decision as a whole. His second error was that the first tier should have found sufficient mutuality. Well, that's the mirror of the first that adds nothing to the debate. And then the third error, he said, was it misdirected itself by taking into account irrelevant considerations at RMC Limb 1, in particular on the reliance on the right to terminate, and he pointed the court to paragraphs 159 to 162. But that's not what the first tier did. The first tier was alive to all of the requirements imposed upon it when addressing the concept of mutuality. It found that there was a contract, found that there were mutual obligations, found some mutuality, and then it addressed, and whether that's to be done at Limb 1 or Limb 3, the revenues terms doesn't matter, but it addressed the significance of the obligations owed by either party and concluded, in effect, that it was a loose relationship that suited the parties, that was not appropriately described as a contract of employment.
Your first point, you say that the assertion by HMRC that the FTT erred in finding insufficient mutuality of obligation in Lim 1, and you say that's not what they did on a fair reading of the judgment. What particular paragraphs of the judgment do you rely on in the FTT to say that that's a wrong characterisation of what they decided?
It's the very careful exercise they do. I'll just identify the headings, but 124 they ask themselves, is there a contract at all? That dealt with Mr. Morm's submissions, which they reject. 135 onwards, they say, well, we've got to understand the terms of the overarching agreements. And they do that exercise from 135 down to 143 and then 144 onwards. So they've found the terms of the umbrella agreements. They then address at 152 the significance of those terms to the individual contract and remind themselves of the right authorities. And then it's 159 onwards where they address the significance of the type of mutual obligations that they have found earlier in the decision and whether that satisfies the notion of sufficient mutuality. And they do that by recognising that, yes, there is some mutuality, that's in 159, but that some mutuality is, in a sentence, line 4 on page 192, that begins, the sentence begins, subject to these points. And of course, these points are the ability of either my clients to change their mind or the referee to change his.
So let me just be clear. Are you saying that if one reads 159, that the fair reading of it is that they did find that the Lim 1 aspect was satisfied by finding that there was some mutuality of obligation, but then they went on in a Lim 3 sort of way to say, but it's overridden by other factors and it's not enough for it actually to amount to a contract of employment?
Well, that is one reading of what they do at 159.
But is that the reading that you invite us to adopt?
Yes, my lady. But
that's very hard to. So I can see how you can say, well, they didn't actually come to a finding one way or the other on Lim 1, but I find it very hard for you to get out of that they actually found that there was mutuality was satisfied at Lim 1.
Well, and that's what I was about to qualify in answer to my lady was that the relevant sentence that says there's some mutuality begins with the words subject to these points.
Mm. But some level of mutuality. Do you accept that there was a contract, an obligation to pay for work to be done, and an obligation to provide personal services? If those are the criteria for Lim 1, do you accept the present? If they are the criteria, do you accept the present?
If I am also directed to ignore the ability of PGMOL to change its mind or the referee to change his mind.
Just if those are the three factors under Lim 1, are all three present?
Yes.
Yeah. Okay.
Subject to the refinement that the obligation to pay for work done and to provide personal service is on the one hand qualified by the PGML's right to change its mind, and on the other hand qualified by the referee's right to change his mind.
Well, that's bringing in another factor.
Well, if my Lord puts to me that those are the only factors, then my answer is yes.
Okay.
But the court has my qualified answer that those are not the only factors.
Thank you. Mm-hmm.
But what the FTT then goes on to do is to remind itself of the guidance from Mr. Justice Briggs, as he then was in Weight Watchers, to identify that there were a number of categories and the obligation has to subsist for the whole of the life of the particular contract. And then in 160, they say it is relevant that either side could withdraw. and that must be right as a matter of law. It's relevant. And they then test the facts of this case against the facts of Prater and find that they're different. And as my Lord, I think Lord Leggett observed, there's no paragraph, one might call it 162A, where they draw the threads together on mutuality as they do on control, and I accept that. But that exercise is being done at 174, because they know they have to stand back, standing back as we are required to do. And our understanding is that's a reference back to paragraph 18 of their decision, Hall and Lorimer, where Mr. Justice Mummery had said, you have to stand back and look at the accumulation of detail. They were following that injunction. So the contention made by my own friend that they have made errors of principle in that approach, we say, is not a fair and appropriate reading of the first tier's decision. My own friend made the point that you can have more than one contract of employment, and of course we accept that. And there may be practical problems where one contract of employment prevents you from discharging your duties in a second contract of employment because you can't get from one job to another, and I entirely accept that. That doesn't tell us anything about the nature of this appeal. My friend was then asked, I think by my Lord Stevens, as to whether mutuality here is a binary concept or whether there is a degree of sufficiency. I didn't hear my own friend give a clear answer to that. For my part, the existence of an obligation is a binary question. The nature of the obligation is not.
No, I asked whether it was binary, whether the control was binary, because he was postulating that all you had to do was establish a level of control, and you could ignore some aspects of control, and therefore it became binary.
I heard my Lord ask that question. I thought you'd asked earlier.
I'm sorry if I misled you. I'm sorry.
Now, as regards the ability of either side to change their minds, there is discussion in the Court of Appeal and in the upper tribunal as to whether this ought to be regarded as a right to terminate. And in a lawyer's sense, yes, of course, that's what a lawyer would say. You've got an obligation, but you've got a right to terminate. The layman would say, well, I've agreed to do this unless I decide not to. Or PGML have said, we've asked you to do this unless we change our minds. Now, you can ascribe to that the lawyer's label of a right to terminate, but either way, it is just a very loose arrangement, convenient to both sides, that could amount to a contract of employment. I'm not saying it doesn't, in all circumstances. But what you have to do as the fact-finding tribunal is to weigh the nature of those obligations against a particular fact pattern, and that is what this tribunal did. As regards the wider point, my little friend suggested at one point a policy angle to this, and he accepted that the test ought to be the same for tax purposes as it is for employment right purposes, and we would say yes. And of course there may well be different policy considerations in each area of the legal code, and those policy considerations may push in different directions. But if the test is the same, we say it ought to be, then one can't ignore whatever policy considerations one might see. But one has to bear in mind that if it is a single test, there are different policy considerations, and those policy considerations cannot, in my submission, carry particular weight. And of course, Parliament here proceeds, for example, in Section 230 of the Employment Rights Act, on the basis that there are indeed two categories: common law employee and a worker, and whatever conclusion this court arrives at does need, in my submission, to respect that divide. Nor is it any part of my case to suggest that merely making a contract terminable at will automatically prevents it from being a contract of employment, because one can quite see that that may leave categories of vulnerable people exposed to clever lawyer drafting to take away rights that they might otherwise have. Now, part of the answer to that in the employment field is auto-cleanse, so the court can look to see whether those ostensible rights of termination on either side are genuine. But more importantly here, this is not simply a case of the putative employer making the employee's right to have work provided terminable at will. This is a contract where either side can decide not to go through with the contract. And my own friend was forced to say, well, if you've got both of those, somehow they balance each other out. But with respect, that won't do. What the existence of both of those rights reveals is that this is a particularly loose arrangement.
That was the point about I put to him about being mechanistic rather than painting a picture from the detail.
Well, Lord, exactly, and we accept and endorse the observation that my Lord put to my learned friend.
And you would say, presumably, it's a factor that the FTT found that these people are not doing it for the money. This is not their livelihood, because you can say an ordinary person, of course, they can decide not to work, but they've got to put food on the table. But that's not a factor here.
We are not in that case. The present category of people are mad about refereeing. They're keen to do it, and it's something they do as a enthusiastic hobby. And of course, if the conclusion of this court were that people in that sort of field were employees, then that would put them in difficulty with their full-time employment. A lot of full-time employment contracts, so you can't work for somebody else. And it would put the engagers here in difficulty in that they would have to confer the full panoply of employment rights on people who may never turn up for work. So they're people you may not call on to use, but they are people, if you call on them, they may never turn up. And if my learned friend is right, they are employees with the full protection that the law affords them. And that might be the right conclusion, but we say it should not be.
Mr. Peacock, you've got 3 minutes.
I am alive to that, my lord. The point about Turner and Sorden, that was a rather odd case where the alleged employee was told, we'll keep paying you, but we don't want you actually to work. And he said, well, if I'm kept out of the market for a while, my reputation and skills will fall away, and so I want a right to work. And the court said, well, no. In the fact pattern of that case, there was no implied obligation to provide work. He should be satisfied by being paid. And the contrast there is with the Devonald case, where there was an implied right to provide work, because it was a piecework contract. The significant difference was, in Turner, he was going to be paid, whereas in Devonald, you weren't paid unless you did work. I've made the point that the court must arrive at a conclusion that respects the difference between employment and workers' contracts. You were shown by my learned friend a whole series of worker contracts, so Windle, Pimlico, the Lord's judgment in Uber and Somerville. All of those reveal two things. First, that the terms of an overarching contract can be relevant in judging the status of an individual contract. Windle, we don't disagree. But secondly, in particular in Somerville, the allegation to the contention before the Court of Appeal was that the Court of Appeal should import into the worker test all aspects of mutuality from the common law employment test, and that was rejected. And rejected for good reason, because it's no part of the statutory test. And then lastly, on control, You will walk through the authorities. We have no disagreement with the propositions my own friend drew from those authorities. They are in effect set out in our written case and in his. But to reiterate in Zeus, what was relevant was the ability to control pursuant to a right of control throughout the whole contract, and there may well be instances where you don't have a practical ability to control for some or all of that contractual term. And that itself doesn't mean you don't have a right of control. We accept all of that. So there's nothing really between us on the principles. And then as to the allegations of the errors that were made, they are in effect set out in the upper tribunal and in the Court of Appeal. They are answered in our written case. But in particular, my own friend attempted to ascribe to the first tier this afternoon, 2:35 p.m. about, the proposition that the first tier had decided there was an inability to step in. And in doing so, he repeats the analysis of the Court of Appeal. That is not what the first tier did. Equally, he spent perhaps 20 minutes or so listing the factors that he thought would justify a conclusion to the effect that the first tier had failed to address significant elements in forming its view about control. But they were in effect submissions he made to the first tier about the significance of all of the elements of control, both on match day, during the match, and in the surrounding contracts. And those were properly weighed by the first tier tribunal and found wanting.
Is it a balancing exercise?
Ultimately, my lord, yes.
In Lim 2?
Well, because the notion is a sufficient degree of control, so yes, one has to form a view weighing up a whole series of factors. It's not a bright line, yes, no test. And that is an exercise that the first tier tribunal undoubtedly did on a fair reading of those paragraphs, in particular 165 through to 169. So, Lord, perhaps with 10 seconds left, if I just revert to one point on mutuality. It is accepted in the authorities that the right to send a substitute is inconsistent with the obligation to provide personal service. So I can say, I'm engaged to come and do this, I'm not going to come, I'll send somebody in my stead. That means this is not a contract of employment. In our particular case, the right of the referee was not to say, I'm not coming, but I'll send somebody else. It was to say, I'm not coming at all. If the former is not a contract of employment, I ask non-rhetorically, how can the latter be? It is conceptually much more inconsistent with the type of mutual obligations one would find in a contract of employment than is the mere right to send a substitute. And well, Lord, unless I can help the court further, those are my things.
Could I ask just one question as to disposal? If we are with you, we restore the outcome in the first tier tribunal.
You do, my lord, yes.
If we were against you, what would we do?
It rather depends why you're against me, my lord, but it would need to reflect whether the first tier erred about mutuality,
yes,
or about control, or about both. But if it were about both, then the order of the Court of Appeal, I think, would have to stand, and this would be remitted, unless this court were to do the exercise itself, which I anticipate it's not going to.
But the order of the Court of Appeal only contemplated the tribunal reconsidering mutuality and control. Is that what you would urge? Or should it be a full reconsideration if it's remitted?
Well, that's really the substance of my question, because if the revenue were to be correct, that what they call, you don't like the term, the first limb of the test is a low hurdle, and much more weight has to be placed on the painting a picture from the detail. Presumably, in fairness to your clients, you would want the third stage or limb to be reassessed as well.
That would have to be the case, my lord, because in effect this court will be providing a new or an updated framework,
yes,
against which the relevant facts would have to be weighed.
Yes. Thank you very much. Well, the court is very grateful to counsel for their submissions and to those who have assisted counsel in presenting the appeal to us in the last 2 days. We will take time to consider the judgment in this case. And we'll revert in due course. Thank you very much. Court will adjourn.